Thank you. The next item of business is consideration of business motion 16102 in the name of Jamie Hepburn on behalf of the Parliamentary Bureau on a Stage 3 timetable for the Police Ethics, Conduct and Scrutiny Scotland Bill. I would ask any member who wishes to speak to the motion to press the request to speak button now. And I call on Jamie Hepburn to move the motion.
Move, Presiding Officer.
No member has asked to speak to the motion, and therefore the question is that motion 16102 be agreed. Are we all agreed? Yes. The motion is therefore agreed. The next item of business is Stage 3 proceedings for the Police Ethics, Conduct and Scrutiny Scotland Bill. In dealing with the amendments, members should have the bill as amended at Stage 2, that is SP Bill 29A, the marshalled list, and the groupings of amendments. The division bell will sound and proceedings will be suspended for around 5 minutes for the first division of the Stage 3. The period of voting for the first division will be 45 seconds. Thereafter, I will allow a voting period of 1 minute for the first division after a debate. Members who wish to speak in the debate on any group of amendments should press their request to speak buttons or enter the letters RTS in the chat function as soon as possible after I call the group, and members should now refer to the marshalled list of amendments. And I start with Group 1, Code of Ethics, and I call Amendment 10 in the name of Katie Clark, grouped with Amendments 11 and 4, and I call on Katie Clark to move Amendment 10 and to speak to all amendments in the group. Ms Clark.
I'm very grateful, and I move amendments 10 and also speak to 11, which we'll come to later, which I believe are fairly straightforward amendments and aimed at improving transparency and increasing the amount of information provided to Parliament. Amendment 11, which I'll speak to later, requires the Chief Constable, when laying a revised code before the Parliament, to also lay a statement before the Parliament which summarises any representations which have been made during the consultation and any representations which have not resulted in a revision to the code. These provisions seek to provide Parliament with information about the arguments and representations made relative to the code. The provision is slightly different to the wording which I proposed at Stage 2, and these amendments were submitted after discussion with the Scottish Government, and I thank the officials for their assistance in the drafting, and I hope that these are now in terms which will enable it to have wide support.
Thank you, Ms Clark. And I now call Sharon Dowie to speak to Amendment 4 and other amendments in the group. Ms Dowie.
Thank you, Presiding Officer. One of the provisions in the bill is to create the creation of a statutory obligation on the Chief Constable to prepare a code of ethics for the police service, such as a code currently existing on a non-statutory basis. In doing so, the bill also requires the Chief Constable to consult a variety of stakeholders when preparing the Code of Ethics. However, in the drafted list of stakeholders that the Chief Constable must consult, I noticed one very important group of people were missing: individuals who have made complaints to the police in the past. The very people who experienced the process this bill is trying to improve. Perhaps the very purpose of this piece of legislation. Presiding Officer, this Parliament knows the importance of including those with lived experience in policy discussions. This new Code of Ethics is no different. My amendment number 4 is therefore very simple. It requires the Chief Constable to consult those who represent the interests of individuals who have lived experience of having gone through the existing complaints procedure. This amendment is drafted to ensure that those important voices are heard without potentially delaying preparation of the code by requiring consultation with too wide a pool of people. It achieves a balanced outcome between thorough consultation and practical considerations, and I encourage Parliament to vote for it. I press the amendment in my name. On Katie Clark's amendments 10 and 11, I think both make minor yet sensible changes to the bill. On Amendment 11, I think a document which sums up any changes of the Code of Ethics would be extremely helpful in the future, as well as explaining why any proposed changes were not implemented, and we will be supporting them. Thank you.
Thank you. I now call on Cabinet Secretary Angela Constance.
Presiding Officer, I was very happy to have worked with both members on the 3 amendments in this group. These amendments enhance the bill, and I'm very grateful to the members for their engagement. Katie Clark's amendments 10 and 11 increase transparency and accountability. Amendment 10 ensures that if the Chief Constable decides not to revise the code at all when the triggers for the review occur, that they need to give reasons for this and explain why no change is needed. Amendment 11 ensures that if mandatory consultees suggest changes to the draft revision of the code and those are not included in the final revised code, then the Chief Constable must publicly justify the reasons as to why that decision has been made. This level of transparency builds public trust and confidence in our police service. Sharon Dowie's Amendment 4 importantly ensures that in preparing the Code of Ethics, the voice of those that have had lived experience of making complaints against the police will be heard. Having this input will help Police Scotland achieve a culture of continuous improvement, transparency and inclusivity. I'm just about finished, actually, but if you're quick.
Martin Whitfield.
Yeah.
With regard to Amendment 11, is it envisaged that only those whose complaints have been completed would be considered by the Chief Constable if they made representations, rather than people whose complaints were underway?
Cabinet Secretary.
Presiding Officer, let me just perhaps clarify what the purpose of Amendment 11. This is in relation to the revised Code of Ethics that has to be laid before Parliament, and the purpose of Ms Clark's amendment is to summarise any representations made during the consultation of the Code of Ethics, and to put on record that if representations have not resulted in changes, what the reasons for that are. And again, just in terms of Amendment 4, in the name of Ms Dowie, if it is helpful for me to add that it is important that the Chief Constable has an obligation to consult and hear the representations of those bodies and organisations that have a role in representing those with lived experience. So in many ways, I think this is quite separate to the process of complaints. I hope that's helpful. And just to conclude, Presiding Officer, I urge Parliament to support the amendments in this group.
Thank you, Cabinet Secretary. And I call on Katie Clark to wind up and to press or withdraw Amendment 10. Ms Clark.
I press Amendment 10.
Thank you. The question is that Amendment 10 be agreed to. Are we all agreed? Yes. The Parliament is agreed. And Amendment 10 is therefore agreed to. I call Amendment 11 in the name of Katie Clark, already debated with Amendment 10. Katie Clark, to move or not move?
Move.
The question is that Amendment 11 be agreed to. Are we all agreed? Yes. The Parliament is agreed. I call Amendment 4 in the name of Sharon Dowie, already debated with Amendment 10. Sharon Dowie, to move or not move?
Move.
Moved. The question is that Amendment 4 be agreed to. Are we all agreed? Yes. The Parliament is agreed. We now turn to Group 2 on vetting. I call Amendment 12 in the name of Pauline McNeill, grouped with amendments as shown in the groupings, and I call on Pauline McNeill to move Amendment 12 and to speak to all amendments in the group. Ms McNeill.
Thank you, Presiding Officer. I move Amendment 12 in my name. There's quite a number of amendments in this section, so I'll try to be concise and clear. I believe that we do require a proper vetting process that gives confidence in policing and public confidence in the police officers in Police Scotland. So Scottish Labour are clear that we do support the vetting provisions and the modernisation of them. Police Scotland carries out checks and manages all levels of Police Scotland vetting. It's an administrative role in managing national security vetting, and with the process being undertaken on Police Scotland's behalf by the Scottish Government. Current force vetting includes recruitment vetting, minimum level required for all applications seeking appointment as police officers or employment as members of staff within Police Scotland, management vetting and those for a designated post. HMIC conducted a review of vetting police and procedures within Police Scotland in 2023, and it's these new vetting provisions that were inserted into the bill at stage 2 without any adequate consultation with those with an interest, such as the Scottish Police Federation, Staff Trade Unions or the Association of Scottish Police Superintendents. So within this grouping, I have sought to delete the vetting provisions, but I want to make it clear that I am probing the Government to respond, particularly in relation to the lack of scrutiny on these provisions, and that is my intention. The Government indicated at stage 1 that they were considering putting vetting on a statutory footing, and they say that it's referred to in the stage 1 report, page 56, in a letter from the Cabinet Secretary, who said that she was exploring the legislative basis for vetting, particularly in the context of the Police Ethics, Conduct and Scrutiny Bill and the HMIC review, assurance review of vetting policy and procedures, which said the Scottish Government should place into legislation the requirement for all Police Scotland officers and staff to obtain and maintain a minimum standard of vetting, and the provision for the Chief Constable to dispense with the services of an officer or a staff member who cannot maintain suitable vetting. So, sure, yes, of course.
Maggie Chapman.
I'm grateful to Pauline McNeill for taking an intervention, and I'm just wondering, given the range of amendments she has in this group, given the recommendations of the HMIC review that vetting was really important and should be put on a statutory footing, how else would we do this in a timely way, given this is the legislative vehicle that is most appropriate? And I am really concerned to see Pauline McNeill's amendments that remove all vetting from this bill, because I think it is so important to every aspect of our justice system.
Pauline McNeill.
So I would agree with Maggie Chapman that the vetting provisions are very important. But as I said at the outset, that I am not seeking to delete the vetting provisions, and I said that only a minute ago. What I'm seeking to highlight is, in my view, that there must have been some coordination between HMIC, who were conducting reviews of vetting, and the Scottish Government. And whether that's the case or not, this Justice Committee were in the position that we got a few days' notice of the specifics, do we understand me here, the specifics of the vetting provisions. So we couldn't take any evidence. We couldn't ask if they were fair and reasonable. We couldn't ask the staff unions if they thought they were fair and reasonable. We couldn't ask the Federation. So it's a matter of principle for me that we shouldn't do legislation in this way, where it could be impactful on those groups of staff. And that's why, and I'm sure the member understands that the procedures of the Parliament wouldn't really allow me to make that point unless I put some amendments at stage 3. So it's just the way it is. But I'd like to reassure Maggie Chapman that I do wholeheartedly agree with her point that we do need strong standards of ethics and vetting. So, the Scottish Police Federation has said, for example, that there had been a general discussion with the Government and officials regarding actual vetting provisions, but no consultation or discussion with them. And the former Scottish Police Federation, Callum Steele, said in his column today that this vetting intervention has led to one of the most flagrant abuses of parliamentary processes in recent years. And he makes the point that no worker should be in a position where they can be sacked on the whim of their employer and never be told why. And that's why I hope that Maggie Chapman and others might consider some of the detail of the amendments I hope the Government will consider. A key concern is the use of vetting as a substitute for misconduct regulations, and in some cases officers who have faced formal misconduct proceedings and received outcomes such as final written warnings could be subsequently dismissed through vetting processes, and this would circumvent the principles of due process and undermines the outcomes of a misconduct system. They say that transparency in vetting decisions also presents a major issue, so officers who fail vetting are often left in the dark about the specific reasons for their failure, with data protection cited as a justification for withholding this critical information. They also say that the application of recruitment vetting standards would be problematic if a serving officer with a moderately long career was held to the same vetting criteria as new recruits. For instance, Scotland currently refuses to disclose detailed reasons for vetting failures to serving officers, and this lack of transparency does breed mistrust and prevents them from understanding or addressing the concerns raised. To ensure fairness and accountability, the service, I believe, must look at disclosure of vetting issues where they can. HMIC say in the report that there are 250 cases that they looked at over a 4-year period where they reviewed vetting clearances, where those vetting clearances had been approved and the applicant had held previous convictions. So it's unclear if the new vetting procedures will have an impact on these cases. So it's not a question of whether you think that's right or wrong, and the question is that we don't know if they will impact on those officers. Although the bill doesn't specify the intervals for new vetting, I think it's suggested by the HMIC that that would be every 10 years. The Superintendents Association said that they were concerned that the proposals in the vetting bill could be open to misuse by the service or authority seeking to create a fast-track or alternative method to dismiss without notice police officers. Put simply, if existing misconduct regulations and/or performance and capability regulations are not used correctly or are viewed as taking more effort or a slower route to deliberation of an outcome, then the failure or withdrawal of an officer's vetting status may be misused as an easy shortcut to dismiss. So, as we should do as parliamentarians when we're looking at legislation, you might think, well, that would never happen. But of course, we've got to account for all scenarios. And importantly, since the Parliament has not been able to examine the new vetting provisions, as I said, including such things as whether or not there should be an appeal. So many officers don't know why they're failed their vetting. It could be a third-party association. It could actually be wrongful information, but they're unable to correct it. So I'm now going to just address the specifics of the amendments and what they do. Amendment 13 inserts a new subsection following the definition of vetting to clarify that it should not be an alternative or substitute for misconduct proceedings. Amendment 14 would require provision for an appeal if, as a result of vetting outcomes, someone is dismissed or demoted otherwise. Amendment 15, the key distinction here between misconduct and vetting, in that misconduct hearing there is a process and you have the right to defend yourself against allegations, where in a vetting process currently there isn't much scope for that. So I want to make sure that there is a clear distinction. Amendment 15 provides that vetting cannot be triggered by the conclusion of misconduct proceedings where it was determined that performance or behaviour was not below the expected standard. Amendment 16 provides for the vetting code of practice to include a need for evidence. This evidence is required to demonstrate that a person is not suitable to be a police officer. Speaking to Amendment 17, it would require the code of practice to include for reasons to be provided if vetting leads to conditions, redeployment, demotion or dismissal. Speaking to Amendment 18, vetting of a serving police officer cannot be the same as recruitment vetting. It should be a different criteria. We currently have police officers convicted of small offences like speeding offences who may fail their vetting, which they might have when they just joined, but they might have 15-year service. So Amendment 18 adds to the definition of vetting to specify that in these sections vetting is separate to any assessment required as part of the recruitment process. The amendment provides that information which has previously been disclosed cannot later be used as a reason to demote someone, because if it's already been considered at the beginning and it's been accepted, it shouldn't be used again, except that it's belt and braces. The other, Amendment 24, is in relation to the deletion. Amendment 19 does the same as Amendment 14 does in section 3A, because there's two sections to be considered. And Amendment 20 is a consequential amendment linked to Amendment 19, which removes the provision on appeals subsection 1, which was inserted in section 50A. Amendment 21 provides the grounds that at the conclusion of misconduct proceedings that cannot then trigger vetting. And Amendment 22 adds to the definition of vetting to include that in these sections vetting is separate to any assessment required as part of the recruitment process. Amendment 23 does the same as Amendments 12 and 13 in section 3A. For the avoidance of doubt, it says vetting is not an alternative to misconduct proceedings in the case that there are concerns about the standard behaviour of a constable. And Amendment 25 is to leave out section 3B, which I said I do not intend to move, and the same in Amendment 26 and Amendment 20. 6 is in relation to the long title. So apologies to members for the length of that. But I did want to explain, given there was no stage 2, as to why I've been quite thorough in trying to flush out some of the issues which we might all agree on, and that what may be fair and reasonable is that we're signing up to something, if we vote for this bill tonight, that has had some debate at least at stage 3. Thank you.
Thank you. And I now call Sharon Dowie.
Thank you, Presiding Officer. My Scottish Conservative colleagues and I remain significantly concerned about the inclusion of vetting within the bill. Vetting was not included in the bill as initially drafted, and so no evidence was taken in the vetting process at stage 1. The Scottish Police Federation have highlighted several issues with the current vetting process. When officers fail vetting, many are not given clear explanations as to why, with many not being afforded the opportunity to appeal this decision. David Kennedy has also highlighted concerns that vetting would be used as a substitute for misconduct proceedings. The Federation is therefore understandably concerned about moving to a system of continuous vetting when these issues have not been rectified. Although many of Pauline McNeill's amendments seek to rectify the issues I've just mentioned, the way this section of the bill was tacked on at stage 2 without being scrutinised by the committee was wholly inappropriate. That said, it is of paramount importance that officers who do not meet the standards expected of them are weeded out, and a more rigorous system of vetting may help to achieve this, as would updating misconduct policies and practices. Whilst I still have reservations about the wording of this section, enhanced vetting may in principle improve public trust in the police, which is the entire point of this bill.
Thank you, Ms Dowie. And I call the Cabinet Secretary.
Thank you very much, Presiding Officer. Before I give a detailed response to each of the amendments in this group, can I just say that I've listened very carefully to Pauline McNeill's remarks this afternoon, and if I have understood her correctly, I understand that her motivation is to be confident and that the measures brought forward will prevent the abuse of vetting procedures. And I very much hope to be able to provide the appropriate assurances to Ms McNeill and other members this afternoon. By way of background information, Presiding Officer, as I set out in stage 1, I intended to introduce provisions for the vetting for police constables and police staff following a recommendation made by His Majesty's Inspector of Constabulary in Scotland after the bill was introduced, to ensure that there is a requirement for all constables and staff to obtain and to maintain vetting, as well as the power to dismiss should they be unable to maintain vetting. The Criminal Justice Committee also made a clear recommendation that I bring forward an amendment to provide the Chief Constable with the power to dismiss anyone who is unable to maintain vetting. And this was also against the backdrop of Lady Angelini's report into the murder of Sarah Everard by serving Met Police Officer Wayne Cousins, commissioned by the then UK Home Secretary in November 2021 and published in February 2024. And in it, she expressed concerns about the lack of periodic re-vetting in England and Wales. And although the recommendations are for English and Welsh police forces, they are also relevant to Police Scotland. I therefore brought forward substantial and meaningful amendments that respond to those reports. Presiding Officer, the basis for placing vetting on a statutory footing is clear, and it will provide the appropriate levels of protection for the public, ensuring that all officers and staff meet and sustain the standards required and that the public are served by a workforce that they can trust. The amendments in Group 2 from Pauline McNeill relate to vetting of police constables and police staff, and I do urge members to oppose all the amendments in the group, apart from Amendments 16 and 17, which I can support, and I will go on to set out my reasonings. But if I can also just add for the record that we did have a substantial and actually very good debate on this at stage 2, and prior to stage 2 and since stage 2, my officials have continued to engage in particular particular with those statutory staff associations, whether that's through the body of the Scottish Police Consultative Forum as well. So, yes.
Maggie Chapman.
I thank the Cabinet Secretary for taking my intervention. I just have a question around some of the concerns raised by the Police Federation, particularly around the ability whether or not somebody who fails vetting can appeal and is given support to make amends if that is appropriate. Is the Cabinet Secretary of the view that what would be in the bill if the amendments that she agrees to pass and those that she doesn't agree to don't pass? Is she of the view that those concerns have been allayed by what the final bill will be?
Cabinet Secretary.
So, Presiding Officer, it's important to, for me to remind people about what's actually in this bill and what the Stage 2 amendments provide for. So the Stage 2 amendments provide for provisions to be made on vetting. Work that has to take place thereafter, hopefully once this bill passes and becomes legislation, is that there needs to be a code of practice and there also needs to be new and updated regulations, and there must be consultation on those matters, both with the statutory staff associations and the non-statutory associations. And just to say that in terms of vetting is an area that judgments will be made on the facts and circumstances of each case. But where people are, perhaps demoted or dismissed, they do have the right of appeal to the Police Appeals Tribunal, which hears appeals against police disciplinary actions. If you can just be with me a moment, I'll just finish this point and then I'll be glad to take Ms McNeill. So in future, the Police Appeals Tribunal will include vetting actions, and I'm happy to take Ms McNeill now.
Colin McNeill.
Thank you very much for addressing that point. I just wanted to clarify that in the statutory appeals provision that does currently exist, does that apply when an officer has already been dismissed and then they appeal it? Because what I'm trying to get at in my amendment is that you should have a right at least to rectify any information that might be wrong that has led to your failing your vetting and possible dismissal. And given that you refer to the regulations, would there be scope then to ensure that there was something in the regulations that an officer could correct misinformation in relation to vetting?
Cabinet Secretary.
So the purpose of regulations is that they can get into far more detail than would be appropriate for us to use primary legislation. You will appreciate that when you are dealing with matters, that are individual to a particular individual or circumstance, that trying to cover each and every eventual possibility in primary legislation would indeed lead to an inflexibility that may, of course, be disproportionate and disadvantage different officers. One of the things, and I think I do touch upon it when I get into the detail of the amendments, is that Police Scotland are very clear that you would need different provisions for recruitment vetting that is different from in-role vetting, and that's again in recognition of welfare issues, proportionality, and of course a recognition of people's service as well. And just again, if I can just provide some further information, that the Police Appeals Tribunal is made up of 3 independent lawyers who are chosen by the Lord President of the Court of Session. I'm happy to take
Martin Whitfield.
Grateful to the Cabinet Secretary giving way into a clarification of where she sees the regulations in respect of appeals that relate in essence to the employment contract and appeals that relate in essence to vetting errors. So in principle, does the Cabinet Secretary agree there should be an appeal within the vetting process where there has been an error in the vetting process that can be dealt with in regulation?
Cabinet Secretary.
Presiding Officer, I mean, if that matter was to be dealt with, the place for that would be in regulations and not in primary legislation for the reasons that I've just mentioned a few moments ago. If I can, Presiding Officer, I would like to address some of the specifics around the amendments. So, starting with amendments 24 to 27, they will remove the vetting provisions entirely from the bill. And I have to say, and notwithstanding Ms McNeill's comments, I am deeply concerned that the proposals to remove vetting from the bill have been made at this stage without any consultation with HMICS or Police Scotland, nor indeed any supporting evidence. If we do not use this bill to introduce statutory provision for vetting and dismissal, this would mean that any meaningful vetting changes that I think most of us want to see and which are in the public interest are likely to be delayed until another parliamentary session at the very earliest. Craig Naylor, His Majesty's Chief Inspector of Constabulary, and Deputy Chief Constable Spears have both written to the Criminal Justice Committee following the lodging of these amendments, highlighting their concerns about Ms McNeill's proposals and the case for a statutory framework for vetting. Victim Support Scotland also urges members not to back these amendments. They have stated their support for periodic re-vetting and the role the vetting provisions in the bill will play in the public having continued trust in Police Scotland. Turning to other amendments in this group, I will refer to some together as they achieve the same effect in respect of the Vetting Code of Practice, which applies to police officers and police staff, and the regulations which apply only to police officers. I appreciate these amendments may be intended to prevent abuse of the vetting procedures, but the proper way to prevent that is through a robust appeals process rather than inserting various provisions into primary legislation which can trigger unintended consequences. I can assure the member that the regulations will be developed in consultation with the staff associations, and fairness for all will be at the heart of the process. Of course.
Liam Kerr.
I'm genuinely interested in the debate, so I just wonder how the Cabinet Secretary responds to Callum Steele's challenge this morning that because of how this section has come about, we haven't heard evidence on the provisions by those who will be directly impacted by them.
Cabinet Secretary.
So I'm grateful to Mr Kerr's contribution. As I intimated earlier, we did have a substantial debate on this at stage 2. I appreciate Mr Kerr wasn't at in committee at that point in time. I subsequently wrote to committee because there was some, can I say, confusion or misunderstanding to the level of engagement that my officials had with all the staff associations, whether that was individually or collectively. And I provided committee with a series of dates where my officials had engaged collectively with police and partners in the context of the Scottish Police Consultative Forum, or indeed whether they had met, and they did meet individually with the Scottish Police Federation and also the Association of Scottish Police Superintendents and also the Scottish Chief Police Officers and Staff Association. So I just want to put on record, without reading out this entire A4 sheet, Presiding Officer, that there was at official level intensive engagement. I of course also meet regularly with staff associations, as you would expect. And if I can just briefly remind that my response was rooted in a very clear recommendation from HMICS and also the Parliamentary Committee, the Criminal Justice Committee, in their Stage 1 report, made a very clear recommendation to me as Cabinet Secretary for Justice and Home Affairs to address. And I gave that commitment to this Parliament during the Stage 1 debate. Now, I appreciate that the Stage 2 amendments, were somewhat involved and lengthy, but, they needed to be so. This is, not a matter that can be dealt with in a few lines. But I needed, I think, and I would hope most people would agree, I needed to meet that commitment in response to a parliamentary committee of this Parliament that I made to Parliament in this chamber. Presiding Officer, if I can move on to Amendments 12 and 22. They amend the definition of vetting to say that recruitment vetting is something separate from in-role vetting and that it is not an assessment as to character, etc. The assessment carried out at recruitment is a form of vetting and is an assessment as to suitability for the role, and so the amendment creates an inaccurate statement. While recruitment vetting and in-role vetting have different implications, they are still both assessments of suitability. The amendment could undermine the basis for ongoing recruitment vetting by leaving primary legislation suggesting that recruitment vetting is not an assessment of suitability and cannot be that when in fact that is exactly what it is. The amendment would also have the effect of preventing the code of practice from being able to make provision about recruitment vetting. And given that existing Police Scotland vetting manual of guidance and the equivalent version in England and Wales, which covered both recruitment vetting as well as in-role vetting, it is desirable for Police Scotland to have the ability to provide for recruiting vetting in its code, and this will help to provide for a consistent and coherent system of vetting. Turning to Amendment 13 and 20, they insert provision which says that vetting is not a substitute for or alternative to misconduct processes where there are concerns around the standard of behaviour or performance of a constable or member of staff. Both amendments risk forcing the Code to send cases down the misconduct route, even in cases where vetting is appropriate. And this could lead to increased costs, take up additional resources that are not warranted, and goes against the Lady Angelini review, which proposed to use alternatives to misconduct proceedings where reasonable and appropriate. They could also open up vetting determinations to challenge, even when the use of vetting procedures was perfectly appropriate, simply because misconduct proceedings were also a possible option. Moving on to Amendments 14 and 19, the drafting sets up the consideration of alternative measures as a separate procedure from the initial decision-making process and a separate procedure from appeal. While there is no issue with the requirement for appeals, as it is intended that there will be an appeals process, the separate requirement for a consideration of alternative measures is problematic. A decision-maker must already have considered a range of possible outcomes and selected the least serious which meets the risk, and a failure to consider less serious measures will be a good ground of appeal. The duplication of procedures required by the drafting could lead to contradictory decisions, confusions, delays and costs. Turning to Amendments 15 and 21, they provide that vetting cannot be triggered by the conclusion of misconduct proceedings, where it was determined that the standard of behaviour or performance was not unsatisfactory. There are many good reasons for carrying out vetting that do not justify a finding that conduct or performance was unsatisfactory, and those reasons might come to light during misconduct proceedings or be part of wider facts and circumstances that were relevant to the conduct proceedings. The whole point of introducing dismissal for vetting is to provide for cases where someone poses a risk, but their conduct and performance are not such as would warrant dismissal. This amendment would seriously undermine that purpose. Amendment 18 would require the Code to prohibit the use of information disclosed during previous vetting, either as part of the recruitment process or ongoing vetting and subsequent vetting as a reason for the person who has undergone vetting to be subjected to a determination. I cannot support this amendment as it would prevent a vetting decision from taking into account a cumulative pattern of behaviour which emerges over years. Something that can seem to be risk managed on a first occasion might become more worrying on a second or third, and it would be necessary to consider this information in a subsequent determination. Stakeholders have grave concerns about this amendment, citing the escalating pattern of behaviour in the examples of David Carrick and Wayne Cousins. Presiding Officer, Amendment 16 I am able to support, as the code would simply be required to set down whether there are any limitations on the types of evidence that can be used to demonstrate suitability or to list those types of evidence, and I hope that would go some way to alleviate some of the concerns we've heard this afternoon. And I'm also able to support Amendment 17 as providing written reasons for a vetting outcome. It would promote fairness and transparency, and I would expect this as part of the process anyway. Thank you, Presiding Officer.
Thank you, Cabinet Secretary. And I call on Pauline McNeill to wind up and to press or withdraw Amendment 12.
Thank you very much. Can I thank the Cabinet Secretary for being thorough in her response and for acknowledging that what I'm seeking to do at this stage is to go over with some, a fine-tooth comb to some extent, to make sure that there is fairness and reasonable application of something which the Parliament didn't get proper chance to discuss at stage 2. Firstly, can I say that the Cabinet Secretary is quite correct to say that in the stage 1 report we did ask for the Chief Constable to have a power where an officer could not, or member of staff could not maintain their vetting. But the proposals that we're discussing now came after the Stage 1 report. So I have to say, for my part, had I had the detail of Stage 2, then I might have taken a different view. Maybe not, but I just wanted to make that point that I did support the Stage 1 report for those reasons, but having had sight of the provisions, this is what I want to examine in some detail. Can I also say I do get some satisfaction from what the Minister said about what she expects of the regulations. For example, ensuring that in not all cases evidence that was previously used to maintain vetting is not subsequently used at a later date. So I think I am satisfied that some of that can be dealt with in the regulations. I also have taken note of what she said about my amendments about what I was trying to do, given the concerns that have been raised by the Federation and the Superintendents Association, though they didn't get a chance to examine these at stage 2, to make sure that vetting is not used where misconduct should be used. I just make a pleading for that to be clear as these regulations go forward. So I said from the outset I didn't intend to move, and so I will seek withdrawal of Amendment 12. I'm not going to move my other amendments for reasons I've outlined, because I think I've got some comfort. But the one fundamental disagreement I've got here with the Cabinet Secretary is in relation to the appeal process. Forgive me that I haven't had a chance to examine the full detail of what an appeal process looks like under the statute. But it seems to me you could already have been dismissed. And then, whereas if you could correct something quite simple through some kind of correction process or appeal process, then that seems to me to be the one that I think is missing. And I don't see... Yes, I will take an intervention from Martin Whitfield.
I'm very grateful to Pauline McNeill for taking the intervention, and I share her concern with regard to the question of appeal in relation to the vetting process itself. There are appeal provisions in the English vetting system where errors have been made, which might indeed have been made accidentally, and information becomes available. And I am a little disappointed that the Cabinet Secretary was unable to give a categoric assurance that the question of an appeal in respect of the vetting process could not be put within the regulations, although she did indicate it might be if it's sought by stakeholders.
Pauline McNeill.
In response to that, I mean, that's when I've got some difficulty. It seems to me that, although we're creating a framework, I do think it should be in the legislation that there should be a right of correction or appeal. not the statute one. Just before, I'm happy to take an intervention. My problem with the statutory one, it just seems that you're already dismissed at that point. But maybe I'm wrong. I'll take an intervention.
Cabinet Secretary.
I'm very grateful to Ms McNeill for giving way, and perhaps I could put it to her just so we have clarity on the record that it is my view and the view of the Government that a key way to protect the rights of staff and constables while allowing for a vetting regime that protects the public is through a very robust appeals process. So for police constables who are dismissed or demoted as a result of failing to maintain the minimum required vetting clearance, they will be able to appeal to the Police Appeals Tribunal, which, as I've outlined earlier, is an independent tribunal. Police staff already have full access to employment tribunal, and in addition, I do believe that, as I've agreed to the proposed amendments by the two amendments by Pauline McNeill to ensure that written reasons will be given for vetting decisions, and that I intend to consult on further safeguards to be built into the vetting processes as part of the vetting regulations for constables. I hope that would go some way to reassure the member.
Pauline McNeill.
Thank you. And I was going to get to Amendment 16 and 17, and I really do fully welcome the Government's position on this, because I do think that will make a substantial difference to fairness. So I'd really like to welcome the Government's response to that. I still remain concerned about not having something in the primary legislation in relation to being able to correct information in relation to vetting. So with that, Presiding Officer, I'm quite content with, for the most part, when it gets to the only amendment I intend to move is Amendment 14 in relation to appeals. I don't seek to be moving the other amendments in my name, and I thank the Government for the response to 16 and 17. Thank you.
Thank you, Ms McNeill. I would advise the Chamber that Pauline McNeill seeks to withdraw amendment number 12. Does any member object? No member objects. Amendment 12 is therefore withdrawn. I call Amendment 13 in the name of Pauline McNeill, already debated with Amendment 12. Pauline McNeill to move or not move?
Not moved.
Not moved. I call Amendment 14 in the name of Pauline McNeill, already debated with Amendment 12. Pauline McNeill to move or not move?
Moved.
Amendment 14 is moved. The question is that Amendment 14 be agreed to. Are we all agreed? Yes. The Parliament is not agreed, and there will be a division. As this is the first division of the stage 3, I suspend for around 5 minutes to allow members to access the digital voting system. Thank you.